Hello guys and welcome to Bharatwaj classes. As I have informed you and told you earlier that in our next class we will be starting with polity segment first, because polity is one of the we can say polity is one of the subjects or the syllabus prescribed by the UPSC, and also its weightage is high in the prelims part and also in mains part as well. And this polity segment alone can either make you sail through the exam or can even drown you in the exam. So this segment becomes very important for this exam. Also, I want to say you that the classes that we will be conducting will be pre plus mains, means we will be discussing some topics in depth, so don't feel bored, because these classes are extremely beneficial not only for prelims part but also for mains parts. And so let's start this session without wasting our time, and we will start with fundamental rights. We will start with fundamental rights. Now let me explain first what is fundamental right. See, in our constitution, you know what is constitution. Constitution is a law book, of course you must be knowing it. So in constitution there are 22 parts: part 1, part 2, part 3 till part 22. Okay, so what do you mean by fundamental rights? First of all, let me clear you. The rights which are mentioned in part 3, the rights which are mentioned in part 3 of the constitution is called fundamental rights. Okay, so rights, rights here, let me, rights, rights can be classified in two types, can be classified in two types: constitutional right, constitutional rights, and ordinary legal rights, ordinary legal rights. Constitutional rights, as the name suggests itself, that the rights which are mentioned in the constitution, rights these are mentioned in the constitution, is called constitutional right. The constitutional rights further can be divided in two types, that is fundamental rights and the rights, fundamental rights which are mentioned in part 3, and the rights which are mentioned anywhere in constitution other than part 3, other than part 3 of the constitution, is called constitutional legal rights. So here constitutional legal rights. Okay, so constitutional rights can be of two types: the rights which are mentioned in part 3, and this is called as fundamental rights, and the rights which are mentioned anywhere in the constitution are known as constitutional rights. Thus we can say that every constitutional rights, every constitutional right is not a fundamental right. Okay, every constitutional right is not a fundamental right, but but every fundamental right is a constitutional right. Every fundamental right is a constitutional right because it is mentioned in the constitution. Part 3 is mentioned in the constitution. So what is ordinary legal rights? Ordinary legal rights, these rights are not mentioned anywhere in the constitution. These are not mentioned in the constitution. So where they are mentioned? Not mentioned in constitution, not mentioned in constitution. They come because parliament has created it. Parliament has given you this right. For example, narega which gives you right to employment, is nowhere mentioned in the constitution, but you have this right because of parliament created it. Okay, RTI Act is also your ordinary legal right. So you must be getting what are constitutional rights and what is ordinary legal rights. Now next, What is constitutional right and ordinary? Now let's discuss what is the difference between ordinary legal right and fundamental rights. So we can say that ordinary legal right is not mentioned anywhere in the constitution, and it comes because parliament has created it. Whereas fundamental right is mentioned in the basic law book, that is in our constitution, in part 3. Part 3. Further, amending ordinary legal right is very easy and can be changed by simple majority. Simple majority. Whereas amending fundamental right is difficult, very difficult. Difficult means it requires, as I said the word difficult, so it has to be done under Article 368, that is constitutional amendment is required. To amend fundamental right, you have to do a constitutional amendment under Article 368, that too special majority, that too through special majority. So you can say that your fundamental rights first of all is mentioned in part 3, and changing it or amending is it really difficult, as it requires a constitutional amendment under Article 368, that too through special majority. Okay. Further, 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 what we can say is that in case your ordinary legal right is violated, you can get your right. In case your ordinary legal right gets violated, so in order to enforce it, you have to move subordinate or high courts of the state. Whereas in case if your fundamental right is violated, you can directly approach Supreme Court, and Supreme Court is bound under Article 32 to get your rights implemented and enforced. So under Article 32, it is a constitutional duty to get your rights implemented. Okay, next. So you must have got up to here. What I have tried to say or give you a basic idea of fundamental right is that, first of all, fundamental rights are the rights which are mentioned in part 3 of the constitution. Mentioned in part 3 of the constitution. ठीक है? Articles 12 to 35. Articles 12 to 35 deals with fundamental rights. Okay, and the term fundamental right or our fundamental right has been greatly inspired from Bill of Rights. Bill of Rights mentioned in American Constitution. America was the first country to give certain rights to its citizens in the form of Bill of Rights, that too in their constitution. So the Indian Constitution is greatly influenced by American Constitution, where Bill of Rights has been mentioned. Okay, Bill of Rights has been mentioned. Next. And part 3 of our constitution is referred to as Magna Carta of India. Magna Carta of India. Magna Carta of India. Okay, Magna Carta of India. Now next. Till here you must have got it. Now let me explain why fundamental right is called fundamental rights. Means fundamental rights, as name suggests, why it is called fundamental. Why it is called fundamental. So why it is called fundamental, let me explain you. First, it is mentioned in our law book, in the law book, basic law book, which is the constitution itself. So it is mentioned in the fundamental law book, that is in the constitution itself. Further, fundamental rights provide not only physical, intellectual, but also spiritual potential, and thus this potential will help an individual to achieve all round development. Okay, how physical, how intellectual, and how spiritual? Let me tell you. Physical, your article, right to shelter, right to pollution free environment. Intellectual, article 21A, which says that it is a fundamental right of every child to get education who is between age of 6 and 14. So it is giving you an intellectual right. Spiritual, your article 25 to 28, which gives you the right to profess, practice and religion of your choice. So we can say that fundamental right not only provides you physical, intellectual, but also spiritual potential, which helps in your all round development, of individual. Next, further, the fundamental rights, if if state makes a law or parliament makes a law which is against any fundamental right, or any provisions of the part 3, then it shall be unconstitutional. Then such a law shall be unconstitutional and void. So what I am trying to say here is that fundamental rights are called fundamental because they are mentioned in the basic law book, of the country, that is our constitution. Further, they aim at providing physical, intellectual and spiritual potential and all-round development of the individual, and thus establishes a true democracy. State cannot take away them. Here, state cannot take away them. State cannot take away them. These laws cannot be easily be taken by the state. State cannot take away them. And if any law which is made and is against any part of part 3, then it is declared unconstitutional and void. So you must have got up to here. Now let's discuss another thing. Features of fundamental right. Features of fundamental right. Features of fundamental right. Features of fundamental right. So first feature that we can say is that fundamental rights is fundamental right is not absolute. Not absolute. What does it mean? Absolute. Not absolute means every fundamental right comes with reasonable restriction. Reasonable restriction means your article 19(1)(a), for example your article 19(1)(a), which guarantees you speech and expression, also comes with restriction and can be restricted on the grounds of security, sovereignty, maintenance of public order, etc. So you can say that the fundamental right is not absolute and there are some reasonable restrictions with every fundamental right. Not absolute and there are reasonable restrictions with every fundamental right. Now next, some rights are available only to the citizens. For example, 15, 16, 19, 29 and 30. These rights are available only and only to the citizens, whereas The rights other than this, other than 15, 16, 19, 29 and 30 are available to both citizens as well as foreigners, foreigners, as well as foreigners. As well as foreigners. Now, third point. Fundamental rights are not sacrosanct. Not sacrosanct. Not sacrosanct. What does the word mean? Not sacrosanct. It means that fundamental rights can be and are prone to amendability. Means it can be amended. It can be amended. Fundamental rights are amendable. Amendable. Okay. Amendable. And it has to be done under Article 368, that too through special majority. Special majority. Next. The next thing that we can say is that fundamental rights are justiciable. The most important thing is that your law or your rights are justiciable. Means in case your rights get violated, your fundamental rights are violated by the state, you can directly approach to the Supreme Court. Supreme Court protects your fundamental right under Article 32. Under Article 32, it is the duty of the Supreme Court to get your right justified, to get your rights implemented. Fundamental rights are divided in two groups. First, fundamental rights in the nature of positive commandments and fundamental rights in the nature of negative. What does these two words mean? Positive here means they say that state shall do something. State shall do this thing in order to achieve this thing. Whereas the negative worded rights prohibit the state from doing certain activities. Let me write or explain you with this example. For example, Article 16 subclause 1 says that state shall provide opportunity for equality to all citizens in case of public employment. In case of public employment. In case of public employment. Now, Article 16 subclause 1. Read the language of Article subclause 1. What is said? State shall not discriminate. State shall not discriminate against citizens on such and such grounds in recruitment of candidates in government services or any services under the state. So if we will look at the language of Article 61, it is trying to say that state shall provide. State has to do something. State को ऐसा करना है ताकि citizens को ऐसा मिले. So it is in the nature of positive commandment. Means this Article 16(1) is positively worded. Whereas if you will look at the language of Article 16 subclause 2, it is trying to restrict the state. It is prohibiting the state not to discriminate. Means negatively worded. This is negatively worded, whereas this is positively worded. So what I am trying to say here is that the fundamental rights can be grouped in two categories: positively worded and negatively worded. Positively worded gives certain benefits upon the individual and says to the state to do certain activities in certain way, whereas negatively worded prohibits the state from doing certain activities. The next thing that, or the next feature of the fundamental right is that they can be suspended. They can be suspended. They can be suspended. Under Article 358 and under Article 359. Under Article 358, it says that when emergency is external emergency, when emergency is external emergency, then fundamental right under Article 19 automatically get suspended. Automatically get suspended. मतलब क्या है? मतलब ये है कि एक्सटर्नल इमरजेंसी लगते ही जो आपको फंडामेंटल राइट मिले हुए अंडर आर्टिकल 19 वो अपने आप ही चले जाएंगे. जैसे वो लगेगा वैसे ही 19 आपका गया. एंड आर्टिकल 359 सेज दैट वेदर इमरजेंसी इज एक्सटर्नल और इंटरनल, चाहे एक्सटर्नल हो चाहे इंटरनल हो, इन दोनों केसेस में जो प्रेसिडेंट होगा, प्रेसिडेंट, इन दोनों केसेस में जो प्रेसिडेंट कैन suspend the enforceability of one or more fundamental right through separate proclamation except rights under article 20 and 21. What I am trying to refer here is that कि जो फंडामेंटल राइट्स हैं they can be suspended in two conditions. First, under Article 358. Second, under Article 359. Under Article 358, it is suspended during external emergency, and when external emergency is imposed, then fundamental right under Article 19 will automatically get suspended. Whereas under Article 359, it says that in case there is external emergency or internal emergency, then president who can suspend? President can suspend that too through separate proclamation. He has to bring a separate proclamation or order to suspend one or more fundamental right except right under article 20 and 21. So you must have got till here. Now further, let's begin further topic. In above discussion, you must have heard that I wrote several things. I discussed state shall not do this, state shall not do this. Look at the language of article 16 subclause 1 and article 16 subclause 1. What it is saying? State. यहाँ भी state आ रहा है, यहाँ भी state आ रहा है. So you must have understood, what you must have understood, that fundamental rights provide protection only अगेंस्ट स्टेट एक्शन. ये आपको किससे बचाएगा? स्टेट के एक्शन से बचाएगा. एक्सेप्ट, बट इसका भी एक्सेप्शन है. उसके एक्सेप्शन क्या है? एक्सेप्शन आर दैट अनटचेबिलिटी your right to life, and also right against exploitation. Through this point, I am trying to make you understand is that fundamental rights provide protection only against the state action and not against the private individual, except rights related to untouchability, right to life, or right against exploitation. In this case, in these three fundamental rights, it will be protected not only against state action but also against private individual as well. Further, fundamental rights are not absolute. I told you earlier also, fundamental rights are not absolute, and they come with reasonable restriction except article 17. That is, untouchability in any form is prohibited. Untouchability in any form is prohibited. So you must have understood that fundamental right is trying to protect you from state action, and there are some reasonable restrictions and are not absolute. So what does the term state mean? What does the term state mean in fundamental right? What does the term state mean? State का मतलब क्या है? अभी मैंने बोला कि स्टेट ऐसा नहीं करेगा, स्टेट को ऐसा करना है, एज डिस्कस इन आर्टिकल 16 सब क्लोज 1 एंड आर्टिकल 16 सब क्लोज 2. तो स्टेट क्या क्या चीज है? तो आर्टिकल 12 डिफाइंस कि स्टेट क्या क्या है. तो स्टेट क्या क्या है? आपका गवर्नमेंट एंड यूनियन पार्लियामेंट. यूनियन पार्लियामेंट, that is government at union and parliament, government at state and state legislature, state legislature, anybody funded by the government, funded by government, or even anybody funded by government, by government but working for government, but working for government, but working for government. These all are state. सो आपको समझ में आ गया होगा कि जो फंडामेंटल राइट है वो आपको किन किन चीजों से बचाएंगे. दे विल प्रोटेक्ट मेनली अगेंस्ट स्टेट एक्शन. एंड व्हाट इज स्टेट? स्टेट आर दिस ऑल authorities: government at union and parliament, state government and state legislature, anybody funded by government, for example DTC buses. Now next, till here you must have got. Now let's start another topic. Discuss article 13. Let's discuss article 13. Discuss article 13. You must have got article 12. Now अब article 13. Article 13. Article 13. So article 13. Let's deal with article 13. So first of all, article 13 subclause 1. What article 13 subclause 1 says? Article 13 subclause 1 deals with pre-constitutional law. Pre-constitutional law. And it says that all the laws enforced in India, enforced immediately before the commencement of the constitution. मतलब कॉन्स्टिट्यूशन को कमेंस होने से पहले जो भी लॉ इंडिया में बने हैं, इट शैल बी अनकॉन्स्टिट्यूशनल एंड वॉइड. इट शैल बी अनकॉन्स्टिट्यूशनल एंड वॉइड if it violates any provision of part 3. violates any provision of part 3. मतलब क्या है कि कॉन्स्टिट्यूशन बनने से पहले भी बहुत सारे कानून थे, एंड if any law which is violating part 3, which is violating your fundamental right, has to be and void. You must have got article 13 subclause 1. Okay, now article 13 subclause 2. Article 13 subclause 2. 13 subclause. Article 13 subclause 2 says, look at the language of article 13 subclause says, article 13 subclause 2, it says that state, write all, let me write full for you, state shall not discriminate. Oh, sorry. Here it says that state shall not make a law that will or take away or abridges, that will take away or abridges any fundamental right, abridges any राइट। पहला तो स्टेट को ऐसा कोई कानून नहीं बनाना है कि जो आपके फंडामेंटल राइट ले ले, या अगर स्टेट और पार्लियामेंट अगर कोई कानून बना भी देता है देन इट शैल बी अनकॉन्स्टिट्यूशनल एंड void, unconstitutional and void if it will violate any provision of part 3, if it will violate any provision of part 3. So what I am trying to say is that as per article 13 sub clause 2, state shall not make a law, state को कैसा कानून नहीं बनाना है, ऐसा कानून नहीं बनाना है that which will be violating your fundamental right or taking your fundamental right, and also if any such law is made which is violating your fundamental right, then it shall be unconstitutional and void if it violates your fundamental right. Got it? Let me simplify once more for you. Article 13 सब क्लोज 2 बोलता है सबसे पहले कि स्टेट को ऐसा कोई कानून नहीं बनाना है जो आपके फंडामेंटल राइट के खिलाफ है या जो आपके फंडामेंटल राइट छीन ले। एंड इफ एनी हाउ पार्लियामेंट मेक सच अ लॉ, अगर ऐसा कानून बन भी जाता है देन इट विल बी अनकॉन्स्टिट्यूशनल एंड वॉइड, अगर वो कानून आपके फंडामेंटल राइट को वायलेट कर रहा है। तो आपको ये समझ में आ गया होगा। आगे बढ़ते हैं आगे बढ़ते हैं आर्टिकल 13 सब क्लोज 3। आर्टिकल 13 क्लोज 3, आर्टिकल 13 सब क्लोज 3 जो है वो डेफिनेशन ऑफ लॉ देता है कि जो हम यहाँ की बात कर रहे हैं कि ये कानून नहीं बनने चाहिए, यहाँ जो आर्टिकल 13 सब क्लोज 2 में ये जो कानून है, यहाँ पे कानून का मतलब क्या है, लॉ का मतलब क्या है यहाँ पे। सो इट डिफाइंस आर्टिकल 13 सब क्लोज 3 गिव्स अ डेफिनेशन ऑफ लॉ, ठीक है, कानून को बताता है। तो कानून क्या है, एनी लॉ दैट इज मेड बाय पार्लियामेंट, permanent laws made by parliament, state legislature, temporary laws made by president, that is ordinances, president, any regulation or any notification, or notification issued by the executive, रेगुलेशन और नोटिफिकेशन, ये आपको समझ में आया।